morning.
Good morning. Before we start, Mr. Jones, let me take just a few moments and make sure we're all on the same page, okay? As I understand it, you're representing yourself, is that correct?
Yes.
And you are not an attorney, is that correct?
That's correct, yes.
Okay. You've sat through the morning, seen how things work. Is there anything you have a question about, anything you don't understand?
I don't believe so. This is actually the second appeal in this matter, so I am pro se, but I have been here once before.
All right. I felt required to ask you that, though.
Yes, sir.
In just a moment, we'll start the process, and what I need for you to do is introduce yourself. And since there's no one on the other side, there's no need to ask about rebuttal time, but when we start, after you've introduced yourself, you can then explain to us whatever it is you want us to know about this case. You understand that today we're not going to render an opinion like the trial court does.
Yes, sir.
We'll file an opinion later on. Okay.
Yes, sir.
Any questions about that?
I don't believe so.
Okay, and you understand that all this is being live streamed too?
I am.
Okay.
So nerves are there, but
Well,
I just took a look at
I don't say it for that reason. I just want you to know that it's out there, okay?
Yes, I just took a look at the Tennessee State Constitution. That didn't help anything either, so I probably should have stayed in here. But needless to say, it's an honor to be here, gentlemen.
You ready?
Right, I am.
All right. Okay, if you'll go ahead and introduce yourself, then you can begin your argument.
Okay, my name is John Jones. I'm the appellant in this matter, and I am pro se, as we've just discussed. First, I'd like to just give you a brief history of the case, because this is, in fact, the second appeal on this matter. The first appeal was, the case number was M2021-00788, and in that appeal, this matter was reviewed in length. So at this point, I was successful in that appeal. It was reversed and remanded back to the trial court for the purpose of determining whether or not substantial harm would exist where the children, my children, the two minor children, Bentley and Sadie Jones, whether or not substantial harm would exist were they to be returned to my custody. So at that time, that is the only hearing in which this appeal is brought forth. I'm going to do my best here to simplify this as much as possible. What's important to know is that the mother in this appeal did not, or the appellee in the matter, did not participate in the first appeal. She chose not to file a brief, chose not to, she would not have been able to present oral arguments, but she chose to accept the trial court's judgment and chose not to seek appellate relief. That's important in this matter because I was successful in this matter. I did not agree. One would reasonably assume that the findings of June 6, 2021 would have been accepted by the mother and that she essentially agreed. I, however, did not agree with those findings and the judgment, and I appealed and was essentially successful. In that opinion, this court ruled that superior parental rights did apply with respect to myself, referencing the Blair v. Baden-Hope statute, and applied and instructed that the trial court erred in using an incorrect legal standard by applying just the Strickland v. Strickland standard, which was incorrect, when it should have in fact applied the Blair v. Baden-Hope standard, applying superior parental rights with respect to myself. Again, they went on with on remand where the trial court was instructed to make findings as to substantial harm. What's important to note in this is that during that time, while the first appeal was under advisement, the mother filed a new petition through her then attorney at the time, and seeking the same action, the one that she chose not to seek appellate relief on. Now, I'll get to that as to why that was inappropriate, why that was should make her petition invalid. But let's take it one step at a time. the most important aspect as it applies to myself, which is this appeal about, is whether or not substantial harm was found in this matter. I believe it was not. I believe it was very clear that a finding of substantial harm did not exist. One, that the court would have needed to make clear findings, strictly, stating that substantial harm existed and to why. The court failed to do so, or they did not, because I believe, again, that substantial harm does not exist. Further, the court made a best interest determination considering myself and the appellee with arguments of 36-6-106. Those arguments, if substantial harm did in fact apply, would have been irrelevant. They would not have needed to make those findings, make that best interest determination. Further, furthering my position that substantial harm didn't exist. So I'm going to reference Blair v. Baden-Hope again, because without substantial harm, Blair v. Baden-Hope is very clear that a parent has a right to parental privacy. In a matter where a parent has claimed superior parental rights, the non-parent bears the burden to show substantial harm. It goes on to say that only if a finding of substantial harm is made, only then may the court make a best interest determination. That means with the absence of substantial harm, the children should have been returned to my custody immediately. That is why the matter on remand could not be heard simultaneously with the mother's new petition.
Let me ask you, the mother filed a petition. You call it new. I don't know if it's new. Anyway, she filed a petition. Did you respond to it? Did you file an answer?
I did, yes, sir.
And you answered that petition?
I did, and obviously contesting that petition. She represented that as an agreed upon parenting plan, because she was seeking to regain custody from the grandparents. However, I had not lost any parental rights at any time, and I certainly did not agree with that. And I also filed a proposed parenting plan myself at that time. So,
Did you object to the procedure that the trial court used?
I did, 100%. In
Well,
fact,
did you file an objection?
no, sir.
Okay. When you say you objected, what do you mean by that?
Well, at the time, the court docketed the mother's new filing as well as my matter on remand at the same time. At the start of that, when the court was catching up procedurally, I've stated my objection that these two matters could not be heard simultaneously, because if in fact that substantial harm was not found and the children were returned to my custody, that would drastically affect the legal standard that the mother would then have to prove, because then she would need to prove that a material change of circumstances had in fact occurred, and not only that it occurred, but the higher standard that a material change had occurred, and that a change of primary custodian was then necessary. You can't do that if we don't have initial circumstances in place at this point. So there's no way to have a material change of circumstances that don't yet exist. And they didn't exist because this court had reversed the opinion reversed the judgment from June of 2021. What should have happened? It didn't
really reverse, it vacated, didn't it?
No, it reversed, Your Honor, with respect. Stating that the court should have applied superior parental rights to the father, myself.
What does that
You're right,
matter?
they did reverse.
What does that matter, though, in that there was a pending petition as between you and the mother? What prevented the trial court from hearing that first?
I'm sorry, say that.
Why couldn't the trial court hear that first?
Well, because at that point, her petition seeks a material change of circumstances. That is what it's asking. And if there's not circumstances in place in the first place, how could we change it? How could they state that a change of circumstances has occurred requiring a change of custodian? At that point, she would have needed to file a petition claiming superior parental rights herself, as she would have been seeking to regain custody from her parents, the maternal grandparents. And at that point, then the maternal grandparents would have needed to show whether or not substantial harm applied with her. They did not do that. They sought to accept the court's judgment from June of 2021, accepting their judgment, and then state that a material change had occurred. However, this court, me exercising my right to appealed and was ultimately successful. This court reversed that judgment that they are stating a material change had occurred. That's why it was, the appellate process is the most important process in our judicial system. I think we could all agree. And in that process, once it was reversed, and this court gave clear instructions to the trial court as to the limited additional findings that they needed to make. That was the only thing, that was the only matter at hand. Again, the appellate court had reviewed this case in its entirety, and these were the instructions that they gave to the trial court, was that they were to find by clear and convincing evidence whether or not substantial harm was in place, or whether or not the children would be subject to substantial harm. Because in the absence of that,
as between you and the grandparents.
Sir?
As between you and the grandparents.
That's correct, because at that point, with the reversal, that's where we were at. And so.
But the mother of the children then filed a petition seeking custody as well, correct?
She did.
And she's on the same level as you are, isn't she?
She would be, yes, sir, except for one aspect. She had the right to participate in the first petition, which she did. She chose to seek that in the first place.
How does that matter at all?
Because because Rule 60.02 does not guarantee of a person the right to relief. They must seek relief in the matter, and that she chose not to seek relief. In fact, the court at that time,
she was satisfied with the grandparents having visitation or custody, was she not?
A reasonable person would assume that. Yes, I believe.
Okay,
I believe
so
you're correct.
there was no reason for her to appeal, was it?
Again, no, she wasn't. But however, I was part of that as well, and I was not satisfied.
And you chose to appeal, and you obtained relief.
Yes, sir.
So it goes back to the trial court to decide. You've got three people ostensibly seeking custody, although the grandparents, according to what the trial court said, don't necessarily want custody. But you've got you and the mother of the children, and the grandparents as sort of a fallback position, correct?
Right, that's correct.
And the trial court made a decision based upon that, did it not?
Well, I think that they made a decision, but what I don't agree with is that I do not agree that it should have been heard at the same time, because the appellate court had applied superior parental rights to myself. And in the absence of substantial harm, I have a right to parental privacy. At that point, only then, if substantial harm had been found, would the court need to make a best interest determination, which is what they did.
How did the trial court infringe upon any of your rights when it held its subsequent hearing when it was sent back to the trial court?
Because it failed to determine whether or not it failed to comply with the order from the appellate court. It did not determine whether or not substantial harm occurred first, because if you can't, how can you hear those two things at the same time and make a best interest determination? We would have one party arguing why she should have custody and why I should not, and then you're asking the court to think about all the questions that they need to answer. The realistic nature, I would think, would be to determine first whether or not substantial harm was in place. Because if it's not, or if it is, the question in itself is simple. There's nothing to consider with me at that time. But substantial harm is in place. If it does not occur, or if they do not show substantial harm, At that point, the court would have needed to simply return custody of the children to myself, because the appellate court had already applied superior parental rights with respect to myself.
What release specifically are you requesting from this court?
I'm requesting that the court reverse this matter and award me a judgment of primary custodian. I actually filed a proposed parenting plan. For some reason, they did not include that in the record, but it is certainly filed at the time with the trial court. And I don't believe that there's any reason as to why. They certainly haven't shown it. The technical record does not show any reason why the court should object to awarding me a permanent parenting plan. The evidence doesn't support it. I mean, that's essentially what the mother is saying, is that you shouldn't award custody to me and that you should award it to her. They failed to prove that, and in that case, Blair v. Badenhope again is very clear that in the absence of substantial harm, only if the court finds substantial harm may they then hold a best interest determination here.
Didn't the trial court do exactly what you say it didn't do, beginning on page 21 of its opinion, when it said, I don't think I've got to make these findings, but I'm going to go ahead and make these findings out of an abundance of caution, and then addressed your issue?
Well, at that point, I don't believe that my issue would have been addressed, because I did not bear the burden of proof. The grandparents did.
I'm not saying that anything about the burden of proof. I'm just saying what the trial court in fact did in its order.
I guess that's where we disagree. I guess that's what's brought me here today.
Okay. All right. All right, sir. Thank you for your argument. We will take this matter under advisement, and we will endeavor to get you an opinion as quickly as possible.
Okay.
And let's see, that concludes the call of the docket for this morning, so we'll be in recess to the call of the docket this afternoon.
Thank you very much.
Thank you.